one definite consequence is that you're going to open a file and you're going to pay. So what happened was we decided to reach out, and we reached out to the best of the best. So we brought the best of the best in studio. So he does the Lord's work every Tuesday. That means he does it pro bono. You ask a question, he dissects, analyzes, and then gives you a reply. And then you decide, hey, are you going to run with it and take it to the next stage? Ama, his advice, lucid as is, will suffice. That said, in studio this and every Tuesday, it is obviously my humble pleasure to give you an advocate of the High Court of Kenya. This guy has got his LLM. He's streaking towards his PhD. And this guy's going to go the full hog. Okay, in the name of the Father and the Son. He is a partner at Ngugi Advocates. It is here in the studio. I give you Advocate Eliud Ngugi Esquire. One more time, karibu. Okay. Thanks for making time. Before we jump in, what are your handles there, Esquire?
Mwikali Ngugi on X, TikTok, Instagram, and Eliud Ngugi on LinkedIn.
All right, now you've got your questions you want to ask Advocate, so get on there. SpiceFM KE. Get on the Facebook, Ama. Dial the number 0719012600. They say 3 score plus 10. That's 70.
Mm-hmm.
Oh, fuck. 3 score plus 10. That is 70.
Mm-hmm.
But then, and if your folks have been blessed to live, 70 plus, you say obviously you start to get forgetful. But then again, then there's certain diseases that come along, and dementia. All right, et al. So what happens when somebody writes a will at 60, e.g., for example, and then obviously they get to be 90, 95. That's 35 years, by the way, difference. What's the 411? I ask this because that is a me question. That's a my question. But you have written in and you are asking Advocate Ngugi this today. You're like, hi, Wakili. My father, now in his 60s, had a successful career and built a substantial property portfolio through his business ventures. Unfortunately, he has recently been diagnosed with dementia. At the time of his diagnosis, he had not written a will. And given his condition, he is now unable to do so. Could you advise us on the legal steps we should take to safeguard his assets? So clearly, anyway, you're not daft. The question here is, could you advise? Yeah. But me, I've got, just as I was reading this, if I was up to some nefarious nonsense, okay? For example, I don't know, I thought this, I'm the Klandi. See how dirty-minded I am. Now, I'm assuming, these are the kids, Esquire. He has recently been diagnosed. Recently. Mm-hmm. If I'm the Klande, that diagnosis, does that now negate that this guy cannot write anything? Obviously, you don't diagnosis of dementia unless, I'm assuming it's, it starts... We are starting at 10, building up to 100. Okay? This is what I'm assuming here. Or even if somebody starts at 10, if I know that so-and-so has been diagnosed with dementia, can I go to a good lawyer like yourself and say, no, whatever that person now writes is null and void?
Can be challenged.
Thank you. That's the word.
Your questions sometimes are very interesting. But I would like to... So what I would say is we would have to ask ourselves some of these questions. What does it mean to have dementia? It's been certified by a professional that you have this condition. And so if you learn of someone who has such a condition, I think what it basically means in Kenya is that one has to be of sound mind, or one has to know what they are doing, or rather, let me use that. Sound mind sounds better.
Yes, please.
To make decisions.
Yes.
And so any other decision made by someone who has been declared to be unwell then can be challenged.
Yes.
And these decisions may go from maybe even attending, for example, we have witnesses who come to court.
Yes.
And they need to, you can tell this person is not okay.
Yes.
We even recently had a case where someone had challenged the removal of a judge because they considered that they did not have, they were not okay. Yes. They had a mental illness.
Yes, yes.
And so generally, when it comes to this, you need to be of sound mind to make any decision. But if the person is not of okay, there are other options that they have. And in this case, I think you're asking me whether you can write a will.
Yes, because you see, like now, because now, for example, you have this person is in the 60s. And like, for example, I don't know the details, but like my folks, okay? My old man's in his 80s. And obviously he's in the legal profession. Now, let's assume somebody of his ilk, but wrote the will, they came to you when they were in the 60s. Okay? Then 30 years, they've God has been great to them, then they've lived 30 years. But then you see now, obviously, by the time you get to your 90s, you start to become, obviously, you're forgetful. Because that's age. Can that will be challenged? Because it's like, surely, there's a 30-year time lapse here.
If it was made now?
Yes.
Or if it was made...
No, it was made
earlier on.
Yes, that's 1994.
No, it cannot be challenged because, you see, when the person makes a will, one of the tests or one of the confirmation they need to make is that they are of sound mind.
Right.
And if they make that decision and allocate and distribute their property, unless there is anything that comes after that can challenge the condition.
Yes.
If you get unwell, well and good. You prepare the document when you were of sound mind, when you knew what you were doing. Right. So you would have a very hard time to challenge the document that was made by the person when he was in good health.
But then it begs the question, advocate, because it's 30 years. Don't wills expire?
Wills don't expire.
Wow.
You only make it null by making another will.
Wow.
So if you have a will, it will stand until the person, the purpose for which it was written is fulfilled. And this is for it to control the estate and the properties of a person after the person has died.
Yes.
So it doesn't expire. You could be 18 years of age today and you're listening to this show. Right. And you prepare your will because, one, you are in IT and you're making a lot of money. And you want to protect your properties. Right. And you live to 120.
There we go. Yes.
And you made that will when you are 18. That will still be in place and it can be used after you pass on.
Okay. Now, in terms of corpus mentis, if this person is in the right state of mind, you as a lawyers, what do? Do you then seek a psychiatrist to sit in with you? Listen, in a nutshell, do you seek medical advice before moving forward in a scenario? Yes.
No, if you're okay, we will just go through the documentation with you.
No, but now you need to confirm because now a child has come and told you, boss, this is Muse. Okay? And you can see, obviously, he has not hit 70. He's not sour. But there's all of this. Esquire, what do we do?
What do you do?
Because now, obviously, please give legal advice. What does one do?
So in this situation, if you come in and, for example, you need to transfer or deal with your properties, and we learn that you have a mental condition, there are two ways to deal with it.
Now, you see, you learned because I'm the one who has told you. You see, there are three of us. There's the old man. Then there's Madi. I'm assuming she's going to be here, perhaps.
Yeah.
Then there's me, Jakababa. The son who's just marinating. All I do is drive him around. For I have nothing better to do. Are we together? So, he's not well. You'll take me at what me and Mother, and even Mother is like, you see, him is going. So you'll just take us at our word?
No, we'll take you as you are. You see, for us, we are just we're just professionals who are here to prepare documentation. So wisdom will dictate if I suspect that you're not in your right mental state. In this case, I would even give you the definition of what mental illness.
Thank you.
Under the Act.
Yes.
It defines mental illness as a person diagnosed by a qualified mental health practitioner.
Thank you.
To be suffering from mental illness.
Yes.
And it also includes someone who is going through addictions.
Yes.
And a person with suicidal behavior. So
an alcoholic cannot write a will?
No, a person diagnosed with alcohol or substance use disorder.
Yes.
If you have been diagnosed,
yes,
you could be an alcoholic, but you haven't
doctors
met
not
that
threshold. Yes.
But if there's a diagnosis that has been made by a doctor, mental illness practitioner, and they're able to diagnose you and say, no, this is not okay.
I'm sorry to digress because this is very important now. So anyone who has been to a rehab clinic, they cannot write a will.
The question would be, and let's say this. The question would be, have you been diagnosed? You go into a facility, or having suffered, or maybe said that you don't want to be, you don't,
good answer.
You want to die.
Yes,
does not necessarily mean that you have a mental illness.
Yes,
you need to be diagnosed.
Yes,
and we need to get that diagnosis by the doctor for us to be able to say, okay,
good one.
Well, we cannot proceed with this action.
Sharp.
But beyond all that, we are saying that you come in and you say that we learn. Maybe you've come with that document from the doctor. We have two options. And in this case, this mzee needs to transfer and utilize the properties, and he's only signatory to his bank account. And the mother who has come to my office says they now cannot even access or shop or eat or feed and take care of themselves.
Yes.
There are two options. One, when the person was okay, there's something called a supporter, and under the Mental Health Amendment Act of 2022, there's somebody called a supporter who is defined as someone who can be appointed by a person who is willing to delegate. So, if you're willing to delegate, and this person who is being supported needs to be one, go through, sign off some documents, and two, he's supposed to be appointed by the public trustee to manage the properties of the person who is unwell or who wants to delegate because they are not in that space.
Yes.
And so that's one of the ways to deal with these properties. The other way of dealing with the properties is you could come, or you could go to an advocate, or you could come to me and we file an application in court. And in this application, we'll be asking the court that the person has been diagnosed with mental illness, and under the mental illness, mental Health Act, there's a provision that the court has powers to appoint an administrator, maybe a close family friend, maybe the wife, or the brother, or the sister, or the son or daughter, to come and manage the properties of the person who has been declared unwell by the doctor. And so you get that court order, and within 14 days, the court is supposed to gazette the court order, inviting members of the public to come and challenge this appointment of you as an administrator. And there are also things you're supposed to do as an administrator. One, you cannot transfer property to companies where you have shares or you're a director.
Right.
The only thing you can do is provide the maintenance of this person. And if you're going to if you're going to sell or take a mortgage or invest some of these facilities and properties of this person who is unwell, you need this to be declared by the court. You need these powers to be given to you by the court. And that's why we would be saying, having that court order gazetted, you can take it now and say, okay, we didn't have any monies to pay school fees for the children who have been left behind or that were benefiting from Mzee. But with this court order, you can take it to now the land registrar, and the land registrar will be able to allow you to sign off the transfer of land or an apartment.
You have given us two. You've added a third one there. But obviously, in instances like this, and I'm sorry to be so callous, it's a matter of time. Literally, time is money. Which one is the fast track process? Is that a fair question? Which one is the fastest of those three?
Of these two?
Of those two.
It will be a court order.
That's number two.
Number two will be
last
first, because the first one, being appointed as a supporter, you see, you cannot be appointed as a supporter if the person has been declared unwell.
Sharp.
So if a psychiatrist or a psychologist writes a diagnosis and says you have a mental illness,
yes,
any appointment of you as Kwach as a supporter,
yes.
This person is being called a support is null and void.
Yes.
But now, let's say these things, you never know when the illness comes to you.
There we go. We go. Yes.
But if you now put the fee structure for the university's fees, and you tell the court that this is urgent under a certificate of urgency,
sure,
you need to hear this within the next 2 weeks or 3 weeks, because there is a child whose school fees is supposed to be accessed from this bank account, which signatory is unwell. Then that would be a faster route than going through. There's no other process here. Yes. There's no other way to deal with the properties of a person who has a mental illness.
So, because we are running out of time, but I find these cases very, very, very intriguing, to say the least. So, long story short, Mwikali, my take home from what you've said, because obviously you don't see such diseases coming. And then you can see the hurdles and what you need to do. Bottom line, you're gonna go to Ngogimburu and ring a bell or knock on the door. But the best thing to do, what you're saying is that once you become a major and you start earning, you start building yourself. Get a will, right? Because at the end of the day, that thing will not expire. Love it. So your final advice to these ones, you're saying what bottom line is?
Bottom line here is, that's a one direction, because under this act,
yes,
sometimes we
what is that again,
forget.
Baba?
This is a Mental Health Act of 2022. But
why, hold on, why is it so new? Sorry. Of
2022.
It's only 2 years old.
Mental Health Act, Mental Health Act Amendment.
Okay.
But the initial act was actually established. Let me tell you. Yes. I saw this and I was like, we already had this back in the day. It was first published and gazetted on 1st December 1989.
Wow.
That's when we first had our first Mental Health Act.
Okay.
And so one of the things that I saw in this act was, when I was going through it, is that a person with a mental illness has a right to employment. Number two, the person has a right to make political decisions.
I don't know why you bring this up now, because I don't understand how I have got the right to operate machinery, but I cannot write a will. What are you talking about?
You have a right,
yes,
right
because
to recognition before the law and enjoy all the legal rights on equal basis, like any other person, on all aspects of life.
But I can't write a will.
But now we'll challenge any will that you write in that state. But you have a right to enjoy.
No wonder it was amended in 2022.
Yeah.
Man, you see what? Time flies when you're having fun. Advocate Eliud Ngugi, thank you so much. I'll see you next week, brother. Cheers.
Sugar